Please be seated. We're here for the third and final case of today, November 21st, 2024. We're joined by Justice Vanderwood as Justice Pro Tem. Thank you for sitting in for Justice Owens. Also appearing virtually is Justice Whitener on the screen to my right. This case is State of Washington Respondent versus J.M.H. and A.M.W. petitioners. Opening is Kevin March for 16 minutes, response by Alexis Lundgren of 20, and 4 minutes reserved for rebuttal. Please proceed.
Thank you, Chief Justice Gonzalez, and may it please the court, Kevin March here on behalf of the petitioners A.M.W. and J.M.H. So our argument today is going to be very straightforward and simple. We have three main points that I anticipate repeating. One is that warrants are a form of legal process. They're therefore procedural, and rules about them fall within this court's rulemaking authority, inherent constitutional authority, and the statutory authority that the legislature has recognized. The second point is that in assessing this question, whether warrants are procedural or not, the focus must be on the nature of the rule, not on the downstream effects that the rule might precipitate. That's consistent with the United States Supreme Court precedent we've cited in our briefing. And then finally, the Court of Appeals and the state do not need to come to the legislature's rescue here. There is a mechanism under RAP 1.1H that allows the legislature, if it feels that that the court rule impinges on its substantive authority, it may act pursuant to RAP 1.1, or if the legal community or the court itself has concerns about the way that the rule is implemented or its effects, it may return to the GR9 process that brought the rule into existence. So with those 3 points in mind, I welcome the court's questions, but there are, as the state and the Court of Appeals has practically conceded here, warrants are indeed a form of legal process. And I'd rely specifically on this court's decision in Fields, where warrants are writs, and writs are a subcategory of legal process, and when we can categorize something as legal process, it is procedural. It involves a matter of procedure.
Did you look at the history of the adoption of this rule? And the reason I ask that question is my recollection is fairly recent, certainly in my experience. And how was the process or the substance of the statute implemented before we even had this rule?
The history, I'm sorry, Your Honor.
Before this rule came to being, were the trial judges guided by the statutory directive?
Yes,
or what else?
I believe only the statute would apply here, and then any other juvenile court rules that might have application in the circumstances.
The reason I ask that question is, did the court rule, when we adopted, affect the statutory requirements, or what was followed under the statute, or more specifically, the statutory authority?
Well, our position is that when this court promulgated Juvenile Court Rule 7.16, that comes into direct conflict with RCW 13-40040 and the warrant requirements there. And where the laws conflict, this court has authority to promulgate rules pertaining to court practice and procedure, and in that event, the court rule prevails over any conflicting law. And I'm not sure if I'm answering Your Honor's question, but that's our position. And Justice Madsen, did you?
Yeah, I had a couple of questions.
Please.
You've described warrant as a court process but actually, isn't a warrant just a authority under the Constitution to arrest someone? having really nothing to do with the court itself, just a neutral magistrate making a decision based upon probable cause and issuing a warrant for arrest.
Well, but yes, it's still the process by which the court compels attendance before it.
But isn't that a different question? How you get from the arrest to the court it might be process, like, okay, once you're arrested on a warrant, then the process is that you have to appear by 9 a.m. in courtroom 5. That's a process. But I guess I'm looking for that connection between issuing a warrant for arrest based upon probable cause and how that becomes a court process.
Because anything that governs the manner and means by which the person appears in court is a process. And I would.
But that's where I'm having a problem. It's not the warrant that results in the appearance of the individual.
Well, it is.
It's the arrest.
Well, but the arrest is authorized pursuant to the warrant.
Right, but the arrest is different than coming to court.
It's one way by which a person is compelled to come to court. The person could voluntarily come to court, like pursuant to a summons, for example. But
that's the directive to get you to court. So a summons is not a way to be arrested. I guess what I'm looking for is the connection, because you have a constitutional provision. That is, you can issue, a neutral magistrate can issue a warrant based upon probable cause. And you think that's a court process?
yes, we do think that's part of criminal procedure. When a warrant issues from a neutral and detached magistrate, that is criminal procedure 101, Your Honor.
Didn't we say that in State versus Fields like a really long time ago?
You did, and I've already referenced Fields, and Fields governed search warrants, and I believe Fields said something to the effect of that this is the process by which people are compelled to come to court. That's how the court exercises jurisdiction over the person. And so our argument is that arrest warrants even more readily compel a person's presence and participation in court by seizing the person and bringing them to court, therefore making the arrest warrant a procedural matter.
I have a different question, and that is, why can't, am I talking on top of someone? Why can't we harmonize the court rule and the statute? You come in today and in the briefs with a clear conflict, and I read the two of them, and I think trial court judge can comply with the prerequisites in the statute and comply with the prerequisites in the court rule, unlike in other cases in the past, like Gresham, where a trial court judge couldn't possibly comply with both at the same time.
Well, I think that Your Honor is correct that it is possible to comply with both at the same time. The problem in A.M.W's case in particular, not J.M.H's, was that that's not what happened. The trial courts tried to harmonize them, but ultimately said that it basically did not need to follow 7.16 because the statute provided the authority that was necessary to issue the warrant.
So I understand we do then get to the question of what does 7.16 mean? Does it mean the trial court gets to consider only the circumstances of the particular violation? And what does substantial harm, substantial risk to the community mean? But on the first question of whether we can harmonize the two, why can't we?
Well, the problem is that the trial court did not harmonize them. And again, I don't think that they can be fully harmonized because the statute provides more permissive warrants than the rule. And so to give the rule any effect, and it should have effect because it is the procedural rule of this court, then that will necessarily come into conflict with the more permissive statute. And interestingly, there has not been a dispute in this case. When I started this case a couple of years ago, that's where I thought the dispute might be. But there has been no dispute from the state or from the Court of Appeals that these rules cannot be harmonized completely because, again, the statute allows a more permissive warrant to issue than the rule. So our position is that they are in conflict because no matter what, the rule requires the heightened showing of serious threat to public safety that the statute does not.
Earlier, you were asked, I think by Justice Johnson, about what happened before this juvenile court rule was adopted. And if my memory serves me, and I'm not sure it's even relevant, but a lot of kids were being arrested for nonviolent crimes, on status offenses sometimes, and disproportionately in certain counties as opposed to others, and disproportionately people of color, kids of color were being detained. Is that accurate?
Yes, that's my understanding, and my understanding too, from why this court might have initially promulgated the rule in response to the pandemic. In fact, because of those inequities in our system, as amicus helpfully point out, this court retained the rule.
Can I ask, I'm sorry, just a clarification on that? The scope, the chief referenced status offenses. Maybe you could talk about the scope of the alleged clash here, this statute and this rule. I mean, in terms of, these are juvenile offender matters, not youth, at-risk youth, or
That's
chins,
correct,
or
Your Honor.
BECA.
These were both essentially post-disposition modification orders at issue that necessitated the issuance of a warrant in juvenile offense cases.
Does any part of this case involve what we might describe as status offenses?
No, I don't believe so.
Counsel, I guess I'm still troubled by this being a court process as opposed to a constitutional right to be free of unlawful searches or seizures, in this case seizures. It's got a constitutional basis. So what if the court rule said a warrant may be issued for juvenile offenders on less than probable cause? If it's just a procedural rule, then if a warrant is just a legal process to get you into court.
Well, that would be unconstitutional.
And why? Is that a substantive rule then?
No, constitutional rules and all of the rules governing searches and seizures are procedural. That would be my response to Your Honor. Even though they're constitutional, they govern process and procedure of what the government can and cannot do to its citizenry. So it's a procedural rule nonetheless.
And the probable cause aspect is procedural?
Yes. I mean, our position is that the determination for issuing warrants, whether it comes from the Constitution, from the statute, or from the court rule, governs the process, the procedure by which people are compelled to attend court.
But neither the rule passed by the court nor the statute passed by the legislature can be unconstitutional.
That is true, Your Honor, yes. So obviously the Constitution is the floor below which we cannot go, but that does not mean that those rights enshrined in the Constitution somehow remove it from process or legal procedure. In fact, the criminal procedure refers to things exactly like Your Honor is saying, Justice Madsen. Searches and seizures are in the umbrella of criminal procedure. There are many statutes on the books that govern arrests, warrantless arrests, things of that nature that are all procedural. And yes, as the Chief Justice points out, those cannot go below the constitutional floor, but I guess I'm having a hard time also with the confusion there in terms of them not being procedural just because they're like enshrined in the Constitution.
Well, I guess I can just imagine all sorts of rules, I guess, that we could promulgate, such as, for example, warrants will only issue on Wednesdays. Procedural, I guess. So
Yes?
what does that do to the inherent authority of a neutral magistrate to consider and issue a warrant at the request of law enforcement when probable cause is developed? Anytime. Why? But now we can only do it on Wednesdays.
Well, I'm not sure that would be necessarily a wise,
Well, wise or not, but it's,
but it would, I don't believe that if that does not interfere with if that still can pass constitutional muster, I think that that would still be a procedural rule. Only Wednesday process is available.
Can I ask a question that I think wants to zoom out between just the procedural substantive distinction? And I guess my preliminary question is, you're not suggesting that's the sum total of the separation of powers analysis? Just
No.
putting it in one of those boxes.
I mean, it's not the sum total, but it seems to be the crux in these types of disputes where we have a statute that governs court procedures and we have a court rule that governs court procedures. The crux of the dispute is whether the court rule can be characterized rationally as procedural. If so, then it falls within this court's authority.
Well, I guess that's where I want to drill down a little more, because we have talked, and I think about like the Zylstra case, doesn't just say, well, what is the nature of the rule, but to what extent does enforcement of this rule impede, interfere with the integrity, the purposes, et cetera, of another branch, the prerogatives of another branch. So could you address that in the context of really what I think the argument here is however characterized, does the court rule interfere with substantive prerogatives under the Juvenile Justice Act?
And our answer is yes, to some extent. All procedural rules do that. All procedural rules interfere with the substantive authority in some respect or another. Just because, and that's why the point has to be, is the nature of the rule procedural or not? If so, then those effects are merely incidental. They are not, and that's where we would rely on the United States Supreme Court precedent that we've cited in the brief. So I see that I'm going into rebuttal, so I'll reserve the balance. Thank you, Your Honors.
Thank you. Response, please.
Good afternoon, Your Honors. May it please the Court. Alexis Lundgren on behalf of the state. When the legislature enacted the Juvenile Justice Act, it intended that it apply to all juveniles adjudicated guilty of a crime. Juvenile Rule 716 supplants this policy determination with its own policy decision that only those juveniles whose noncompliance poses a serious threat to public safety should be subject to the Juvenile Justice Act. Juvenile Rule 716 does not set forth a procedure that pertains to the essentially mechanical functions of the courts. Instead, it makes a policy determination reserved to the legislature. For those reasons, the state is requesting that this court affirm the Court of Appeals decision and find that this rule is substantive and violates the separation of powers.
In your briefs, you acknowledged that warrants are typically considered process, but because this process in particular has such a big fat impact on substance, we should consider it substance. Are you walking away from that position?
No, Your Honor. I think, so going back to the petitioner's discussion of the federal case, Hannah v. Plummer, and talking about the incidental effects, what the court was talking about there is the state statute required in-service or in-person service, and the federal rule required mail-in service. And so, of course, applying the state rule versus the federal rule of civil procedure would result in either a case which had only been served by mail being dismissed or being allowed to proceed on the merits. So that's a case in which I think there are some incidental effects relative to a procedural rule about how service is accomplished.
But we have a whole line of Washington State Supreme Court cases where we've made decisions about court rules that had a really big impact on the ability of the case to proceed or the defendant to be held. And we've said, if it's process, it's procedural. State versus Smith was about the constitutional right to bail under the Washington Constitution. But the rule said one thing about the prerequisites to bail, and the statute said another. And this court clearly held this is a procedural topic, even though it's designed to protect a constitutional right. It's procedural. Court rule trumps the statute. Same with Gresham under the evidence rules, which I think implicated due process considerations. and the procedural issue is clearly dispositive, the court reversed the conviction. So dealing with Washington State court precedent, do we have to overrule those decisions to agree with you?
No, Your Honor, because I don't think that, going back to one of Justice Stevens' questions, the question is not as rigid as just procedural or substantive. The ultimate reason that we're discussing the distinction between substance and procedure is because we're attempting to preserve the separation of powers. And the separation of powers includes the ability, certainly, of branches engaging in coinciding activities, but also that one branch should not be accomplishing the tasks that are more properly the subject of another. In Smith, the court was talking about bail and the power to hold an individual and said that that was procedural. I think that case needs to be considered in the context in which, or the context of the issue presented. And there, that rule, the Smith court specifically talked about how bail related to ensuring the alleged offense would be heard by the court. And so I think in all of these cases, where the court is categorizing something that brings the individual into court and talking about the court's authority to be able to do that and categorizing it as a procedural matter, that it is actually related to, there's a crucial distinction between something that permits the court to bring an individual into court in order that the case may proceed, as opposed to a rule that prevents that. The purpose of a bench...
Well, the topic is the same. The topic is prerequisites to the court issuing process, whether it be the warrant, like in Fields, or the detention order, like in Smith, bail pending appeal, or juvenile warrant. In this case, they're all sort of outcome determinative and really, really important.
And I think, Your Honor, there are some cases where there's going to be a gray area, and I think our case law acknowledges that it's not always clear and that there's not always a clear line between what's substantive or what's procedural. And so I think the ultimate issue needs to go back and look at, are the separation of powers violated in this case? So even if something could be technically categorized, a bench warrant is typically used as a procedural rule, but it's used as a procedural rule in order to bring an individual into court, in order to bar the court from being able to bring a certain class of individuals into court. That's operating in a fundamentally different way than we typically look at why the court
What if we
has...
could say that the trial court can comply with both the statute and the rule at the same time? The statute lists certain prerequisites to issuance of a warrant. The rule lists certain prerequisites to issuance of a warrant. A trial court is certainly capable of complying with both. It might not lead to the result that you want, but the trial court is certainly absolutely capable of complying with both. How is there a separation of powers problem then?
So I guess I would say that I agree with Mr. March here, and I think that there is a crucial conflict that can't be harmonized. And so what RCW 1340-0401A says is that the court may issue a bench warrant if the juvenile in a juvenile offense proceeding has violated a court order or the terms of their release order. What Juvenile Rule 716 does is limit it to only those violations whose specific individual, the individual circumstances of those violations poses a serious threat to public safety. So there's a lot of individuals, and both of the juveniles in these cases, the state has conceded their individual non-compliance issues did not pose a serious threat to public safety. So I don't see a way for the juvenile court to comply with both the court rule and the statute.
Counsel, what's the intent? It seems to me that legislature intended that juveniles be held accountable for court orders.
Yes, Your Honor.
So does the juvenile court rule undermine that intent?
Yes, the state's position is that it does. It makes a choice that only certain juveniles who are behaving in a specifically dangerous way are permitted to be held accountable under the Act. And the Act is obviously for the youth to be held accountable, but also to connect them to services. And those services are some of the services that the petitioners are actually wanting the juveniles to be engaged in order to address the causes of juvenile lawbreaking.
But counsel, where does it say that a court can't enforce its order or a court can't use its coercive authority over a juvenile?
Your Honor, if the juvenile does not pose, if the individual circumstances of the juvenile's noncompliance don't pose a serious threat to public safety, I suppose the court can issue modification orders in absentia if it meets that criteria.
There's nothing that prevents a court from having somebody come in to coerce their presence in a court.
I think the issue, though, Your Honor, is that what if the individual refuses to come to court? Then there's no other mechanism by which the court can compel the juvenile's presence into court.
But if
Why, I'm sorry, could I just ask a follow-up? Why not a summons?
In a lot of these cases, there have been summons, and the state would absolutely support, a process might look like the court needs to attempt to secure the juvenile's presence by issuing a summons prior to issuing a bench warrant, or something of that nature. But the court then has no authority, or under the rule, then the court has no power to bring the juvenile into the court if the juvenile decides not to comply with the summons.
Okay, sorry, Justice Johnson.
You've read the rule provision, and I want to have you address this. The requirement that the person pose a serious threat to public safety is sort of a high burden to establish. Yet you mentioned the programs or the noncompliance with the court order, which I would think would, by definition, include conditions that were to address or intervene in the youth's illegal activities. So why would the noncompliance with the programs that's supposed to stop them from continuing their criminal activities almost by, if they don't do those things, satisfy the pose a serious threat threshold? I never saw that as a big hurdle.
So, Your
We
Honor,
don't want the kids to be continuing their criminal activity. We put them in programs to address those. We intervene in their lives to redirect them.
right. And Your Honor, I think the language in the rule that makes it so restrictive is that the rule says that the individual circumstances of the violations of the noncompliance must pose a serious threat to public safety. And so the state is struggling in some ways with those situations where, I don't know that under the plain language, a serious threat to public safety includes tagging school property with gang symbols, which is what A.M.W is doing, or attempting or threatening to commit suicide. Those are things that don't necessarily pose a serious threat to public safety, but they are something that is very concerning, and they're the types of behaviors that are attempting to be addressed by the services that are offered in the juvenile offense proceedings, that are facilitated by the court being able to issue a bench warrant if there is significant noncompliance to bring the juvenile into court to answer.
Into court and detain them in jail.
So, Your Honor, detention does not necessarily need to follow from a bench warrant. So the bench warrant procedure is RCW 1340-0401A, and then 1B says, once the bench warrant is issued, then the court will hold a hearing to determine how to address the juvenile's noncompliance. And that's when that prong of the statute, where it talks about all of the different reasons that a court could detain the juvenile, would come into play. So those would include things like the juvenile is a threat of harm to themselves. So what the legislature has said that detention can occur, but the bench warrant is separate from that.
In J.M.H, the judge who issued the warrant joined the Court of Appeals and reviewed their own decision.
He sat on, we didn't reach the merits in the Court of Appeals, so he did sit on the panel that dismissed the appeal for failure to timely file, Your Honor.
And you think since that's procedural, not substantive, it's okay?
Oh, no, I conceded that that Judge Cooney should have recused himself, Your Honor.
And so what flows from that failure to recuse?
Well, I think at this point, I'd say that this court can make its own determination about whether or not that case was properly subject to appeal. It was filed untimely as to the bench warrant. It was filed timely but improperly filed as to the modification order. So it wasn't timely filed, and here there's no extraordinary circumstances since the case was already, these issues were already under review in A.M.W. There are no specific, there are no extraordinary circumstances. It's simply the juvenile deciding not to show up to court.
Well, we've got an interpretive issue of 7.16 in,
J.M.H.
thank you, J.M.H, that we don't have in A.M.W, so.
Though I would say
Moot
that the
as it
court
might
could
be,
reach.
and reversible as it might be, there's still
Yes.
an issue it presents that the other case doesn't present.
Yes, though I think, Your Honor, if the court determines that this rule is procedural and doesn't violate the separation of powers, it still would need to interpret that rule in order to apply it to A.M.W's
In A.M.W.
case. I've conceded in both cases that I don't think under the plain language of the rule that either of these juveniles their noncompliance posed a serious threat to public safety, though.
So on that question of the scope, the individual circumstances of.
Yes.
Tell me how that plays out in a failure to appear. I'm trying to envision a situation in which a mere the individual circumstances of a failure to appear, when the whereabouts of the youth are unknown, could ever be shown to pose a serious risk to public safety.
Yes, and that's one of the state's concerns. I think there could be situations where the circumstances that are possibly going on outside of the courtroom that are ongoing at the time of the failure to appear, and this might be somewhat of a stretch, but that possibly because the juvenile was engaging in those things in the community, if the probation officer happens to know, or if somebody within the system happens to know and reports that to the court, that maybe that could be a situation where the circumstances of the failure to appear posed a serious threat to public safety. But I think ultimately it's not particularly functional. I don't know that there's any situation in which it would be really clear-cut where a juvenile's absence from court without knowing where they are or what they're doing would pose a serious threat to public safety, Your Honor. So, Your Honors, I would just like to address one thing that the petitioners said, and they said that under RAP 1.1H, if the court rule impinges on the legislative prerogative to define policy, that the legislature could do something to undo that in a certain sense. And I'm not familiar with how that would be accomplished. If this court holds that this rule is procedural and therefore does not violate the separation of powers, I don't think the legislature can then go and make a rule that says essentially what it says now without then coming into conflict with this court's determination that the legislature doesn't have authority to regulate process in that sense.
So harmonization is not possible from your viewpoint. And that was the question I was going to ask. If the legislature, if we disagreed with your interpretation, they just added a phrase to the statute that said, notwithstanding Juvenile Court Criminal Rule 7.16, and the rest of the statute remain the same. The trial court shall. Where would we be if we disagreed with your procedural substance of the agreement? Would the legislature have the power to override our decision?
I don't believe so, Your Honor, because this court is the ultimate authority on what the law is and what is constitutional or what's not constitutional. And so if we're saying that the legislative provision at issue here is essential, it's a violation of the separation of powers because it's a truly procedural matter that's more rightly in the position or within the prerogative of the judiciary, then I don't think there's any rule that the legislature can make that directly contradicts Juvenile Rule 716.
Though that seems a bit of a chicken and an egg problem because you're saying this isn't purely procedural. Is your position that if the court determines this rule sounds procedural or operates procedurally, the legislature has no power to legislate on matters of procedure?
No, Your Honor. I think our case law says that the legislature and the judiciary often both engage in procedural type activities. So like the evidence rules on business records or privilege. So they coincide, and then the only time that a true separation of powers issue comes up is where there is an irreconcilable conflict with statutory provision and a court rule. And then at that point, the court determines whether that's an issue that really belongs to the legislature or whether it belongs to the judiciary.
I'd like to press you one more time on harmonizing the
Yes.
two. The statute provides certain minor prerequisites to issuance of a warrant, certain prerequisites. The court rule provides additional prerequisites to issuance of a warrant. And you're saying that that's a conflict because the trial court should be able to issue the warrant. Trial courts must issue warrants according to the statute. But what about the example where, let's say 7.16 doesn't exist, but a juvenile fails to appear and the judge says, well, I see that the legislature is instructing me to issue a warrant, but the rule here in my court is I always give them a second chance. This one hasn't had a second chance. We're giving them a second chance, and let's see what happens. So I'm not going to follow the statute. Trial court, of course, has the power to say that, doesn't it?
Yes, Your Honor. And I see I'm out of time. May I have time to respond and
Yes, you may.
conclude? Thank you, Your Honor. Yes, Your Honor. And I think the difference there is that the trial court needs to, in order to perform its constitutional functions, have some discretion to issue or not issue a bench warrant, but it ultimately should rest with the trial court, and there shouldn't be a rule that basically says as a categorical bar, you cannot issue a bench warrant for failures to comply with court orders absent a serious threat to public safety, because what that does is say that the juvenile court can't, even if it wants to, bring that juvenile into court unless there's a serious threat to public safety. So I think the juvenile court having discretion is in line with a lot of the other cases where when the court has talked about the power to hold a defendant and to adjudicate cases, it contemplates that it would be the court having discretion to call individuals into court. So for those reasons, I would request that the court affirm A.M.W. and J.M.H. Thank you, Your Honors.
Thank you, counsel. Rebuttal, please.
Mr. March, if I could save your time by asking you the question before they start your clock. On that last point, I'm interested in this idea that if the warrant is part of judicial power for bringing people into court, and courts necessarily have discretion, then I wonder how you address this rule in that context. And let me give you the analogy I'm thinking of. We might have a criminal rule or a criminal law that formerly criminalized simple possession of marijuana. And we have a prosecutor in a county who, in the exercise of discretion, says we're just not going to prosecute cases on that. Seems within the discretion, notwithstanding rule. Is there anything comparable going on here when we look at this as the writ power, inherent judicial power, that it could be exercised by a superior court and not predetermined by a set rule?
I'm actually not sure I fully understand, to be quite honest, that question. So to clarify whether the court itself has the inherent authority to just determine discretionally whether or not they're going to issue a warrant or not, yes, the court does, irrespective of the statute or the court rule. The court is not required to issue a warrant in any particular circumstance, if that answers Your Honor's question. And to get to Justice Gordon-McLeod's question about harmonization, I think that harmonization here has to only work one way. If the trial court, it can be harmonized if the trial court complies with both the statute and the court rule, but the court rule has the more onerous burden. So if, as we had here in A.M.W., if that does not happen, then the rule and the statute are in disharmony. I'd also like to mention—
Counsel, before you go to a different topic.
Please.
If a trial judge decided that they were going to issue the warrant without having found that there was a serious threat to public safety, what's the consequence?
The consequence would be that the judge has acted in violation of the law,
Well, the court rule, but.
which is
but
the controlling law here.
Presumably, there was probable cause in my hypothetical. There's probable cause, trial court says, you know, I don't really care that it's not serious. It's serious to me because they've violated this order 15 times already, so I'm issuing a warrant.
That's exactly this case, and
Yes, it
our
is.
position is that that violated the law because
Well,
where
the law, you say the law, it's the court rule.
the court
where are the
rule
con-
is the controlling law.
And what are the consequences for violating the court rule?
Well, the consequences would be further review and an illegal bench warrant issuing. That's what has occurred here.
The bench warrant would be a violation of their constitutional right not to be seized? I guess I'm just trying to understand what happens when you have a warrant that's issued on probable cause, but is not in line with the court rule. Do we throw the warrant out? Is it unconstitutional?
No.
So what do we do with that?
Well, the warrant does need to be thrown out, yes, because it is not authorized by law. And the law in this circumstance, Your Honor, is the court rule, because where the court rule governs a matter of procedure, it is the controlling law,
Okay, so-
regardless of any conflict in the law or in any statute.
Let me ask you if during the issuance the service of the warrant, contraband is found, and now we have a criminal charge that arises out of the seizure because there was an arrest warrant, which is legal and supported by probable cause, and we have evidence now of a crime, and the crime is charged. Is the crime dismissed?
Potentially, if the warrant is invalid and there was never a valid basis to arrest, yes.
So doesn't that sound sort of substantive-y?
No, because it's still,
Substantive.
any search and seizure issue, it falls within the purview of criminal procedure. It is constitutionally, but it's not substantive. There is a difference, and I agree with counsel that there's not always a clean line that can be drawn between substance and procedure. That's why our proposition is, if it can rationally be characterized as governing court practice or procedure, then it is within this court's authority to promulgate rules.
I know your time has expired, but I have a question, and then we'll ask you to summarize the relief that you've requested, unless another of my colleagues also has.
Certainly,
Question.
Your Honor.
We've talked a bit about separation of powers, and the legislature, through a statute, has said, you, trial court judge, have this procedural authority to issue a warrant. And then by court rule, the Supreme Court has said, we're actually going to limit that authority within our own branch. So it's the Supreme Court limiting the authority of its own branch, the judicial branch. What's the separation of powers problem?
We do not see a separation of powers problem, as we argued in the first portion of the A.M.W. brief. that this is a longstanding 100-year-old system where the powers are shared. And I was, going to get to this point hopefully in rebuttal, but all of the branches' prerogatives are the same in the circumstance Your Honor describes, that court procedure, rules about court procedure are what all branches of government have determined control. They are the controlling law. When there's any conflict in the laws, the court rules trump all other laws.
Chief, could I ask a follow-up to your question? Though I'm not sure your reason for concluding that is the same as what I heard as the premise of the question. What if the situation were the opposite? What if the legislature allowed a broader swath of behavior, or excuse me, a narrower, tighter restrictive guidelines, and the court said, I'm going to issue a warrant on lesser grounds? Same answer because it's procedural?
Yeah, I mean, the court ultimately has the say over procedural matters, and as we've seen time and time again, the legislature has ceded its authority. I mean, it's very much through RCW 204, 190, and 200 expressly ceded that very authority to the court in procedural matters. And to summarize, we are asking the court to reverse the Court of Appeals decision in the A.M.W case and reinstate the criminal or the juvenile court rule as the law. And in J.M.H's case, we're also asking for the same essential relief, reversal of the Court of Appeals. Thank you, Your Honors.
Thank you to counsel for your arguments and your briefing. The case is submitted. We are adjourned. The Supreme Court is adjourned.